I'm Dwight Golan, and I'd like to introduce this year's winner of the Award for Outstanding Scholarly Work in Dispute Resolution, Stacy Strong. Stacie is Associate Professor at the University of Sydney School of Law. She's also co-director of the university's Center for International Law. We've known her for many years before that as the chaired professor at University of Missouri's Outstanding Program in Dispute Resolution. Stacie has also taught at Georgetown Law Center and been a fellow at the Max Planck Institute, University of Tokyo, a fellow at the US Supreme Court, and at other eminent institutions. She holds a JD from Duke, but she also holds 2 doctorates, one from Oxford, one from Cambridge in Great Britain. She's an American lawyer. She's also a solicitor, qualified in Britain and has practiced in both London and the United States, and brings this perspective to her writing. Today, the key, however, is her scholarship. At one level, it's been immense, with more than 100 articles, monographs, several books. Just since 2020, that's 2 years, I see 13 published book chapters and 6 articles. Quantity matters, but the important thing is quality. And to me, it's significant that the International Institute for Conflict Prevention, known as the CPR Institute, has for years conducted an annual competition for the best single article written in the field, with a jury composed of scholars and practitioners. Stacie has won the award 4 different years, which I think is unparalleled in the history of CPR. If colleagues of hers were here, they would tell you she's taken as an extremely serious scholar, as well as a very productive one. One of them asked, did she actually sleep at night? I can't tell you whether she does or not, but I'm delighted to introduce Stacy Strong as this year's award recipient.
Thank you so much, Dwight, and thank you to the ABA and to the Dispute Resolution section for this great honor. I'm very much in awe of my fellow awardees in the previous years, and I'm just so proud to be part of that lineage. I also want to thank, as Dwight suggested, my colleagues at Mizzou, because without their support, and indeed, as you're going to hear in my brief remarks, without their contributions to my kind of scholarly development, I would most definitely not be sitting here in Australia, mind you, but I would not be sitting here today. So what I thought I would do is kind of talk a little bit about my career as both an explanation of why perhaps I'm sitting here in front of you, and perhaps inspiration to what all of us might be thinking about in terms of our scholarship. For the most part, so just a brief little tidbit, I'm bored easily, which means I don't specialize in any one thing because it just doesn't hold my attention long enough. So why have one kind of legal qualification in one country when you can have 2, or in fact 3? Why should you specialize in one type of sport when you can do multiple? So I used to be a triathlete. I used to do eventing with horses, which also involves 3 different disciplines. So I like putting different things together. To me, it's really fun to find those synergies and kind of discordant elements, and try to figure out either comparatively which is better and why, or let's just put the 2 together. You would think I would be a great cook with this kind of mentality, but in fact, I'm not. In that sense, I'm just by the book, follow the recipe. So there's 3 areas of research that I have really used that technique of putting 2 diverse elements together and creating something new. And I find this fascinating. I also find it incredibly helpful because practitioners need that kind of assistance. They are very often seeing the overlap of different disciplines, and they need our assistance as scholars to help them kind of move along the path. So most of you know me, I think, as kind of the class arbitration person. So the first subject I'm going to talk about is the class arbitration element. As you well know, class arbitration began in the United States in the mid-1980s when US courts said, hey, we've got an arbitration clause, but we also have a large number of individuals who could normally proceed under a class action. What do we do? And for the next 20, 30, 40 years, they've been struggling with the what do we do issue. But in terms of my research in class arbitration, I very much looked at it from the perspective of both specialties, civil procedure and kind of what class actions were trying to achieve, as well as arbitration and what it was trying to achieve. And then, of course, I took it international and comparative because for me, it's not fun unless you get to travel to places like France and, England and do other exciting things there. So I've expanded to class and mass arbitration as well. But that process of looking at the goals and values of those two different systems and then how they can and whether they should be put together was really, really eye-opening. In fact, when I began kind of my class arbitration journey, I had intended to say that it was the devil's spawn and that it was just the most horrible thing on the face of the planet. And I know that there are people listening to this who think, well, it is. And so why didn't you just stop there? But the more I looked into it, the more I saw that class arbitration, properly done, did achieve all the natural justice or procedural fairness goals that we have in both arbitration and the civil procedure system. And then again, I looked at these international processes from Spain, from Germany, in the investment arbitration context to see how and whether they were doing the same. And in fact, the US class arbitration system is not, I suspect, the optimal system, which will be a shock to many who think, of course, that the United States does fantastic in all realms. But I would say the German model, which please see my considered writings, I think the German model is actually superior to the US class action model. So that was kind of my entree into this putting things together approach. The next step that I took was trust arbitration, or also known as the arbitration of internal trust disputes. For many, many years, trusts, which is, you recall from law school, are a mechanism to convey or hold property. Trusts were used, or arbitration was used to have to solve disputes between like the trustee and a financial advisor or somebody outside the realm. So that was not in any way kind of complicated or difficult. What was more difficult is when there was a dispute involving the people who were parties to the trust. The trustee who holds the property beneficially for the benefit of the recipients, the beneficiaries. Could you have an arbitration between them? And this was assisted by the fact that I was teaching trust and estates at Mizzou at the time. So again, here's where my thanks to my Mizzou colleagues kind of comes to the fore. And I have to admit that I was one of those freaks of nature who adored trust and estates when I was in law school. And so I was very happy to teach it. And I saw that many of the aspects of trusts could benefit from arbitration. The privacy that is related to trusts. Many people use trusts to convey property, dare I say secretly, sometimes to illegitimate children or to others who they don't want the family to know about. But there were other attributes that just kind of cried out for arbitration. And so I started to think about, well, how can we put these two things together? And I was assisted by the fact that one of my colleagues at Mizzou is one of the United States leading trust lawyers. And again, looking at the procedural fairness to all parties involved with a potential arbitration, and then the contractual nature. How do we get into arbitration? It's a creature of, we often say a creature of consent, meaning a creature of contract, which is not necessarily true, as my colleague Amy Schwartz would tell me, because she's a contract professor. But a trust is not a contract. So what do we do? How can we impose pre-dispute arbitration agreements in this context? And so that was a fascinating foray, and I hope to get back to that and do some more work in that field kind of when my next project comes around. So trust arbitration, putting two things, the trust world and the arbitration world together, because until I was doing my work, they didn't talk to each other. And so this always made me scared. The trust law people were trying to create arbitration rules and completely ignoring the realities of arbitration as we know it in our field. And then our arbitration colleagues were also, and dare I say, equally frightening, creating trust arbitration rules that did not understand the nuances of trust law. So putting them together was, again, hopefully a service to the legal community and the practitioners, but also a very interesting academic exercise. The things now that's all the arbitration people. The mediators in the room are probably, running out to get a cup of coffee because they're like, she's an arbitration specialist, and why do we have to listen to her? But my most recent kind of work has been in the realm of international commercial mediation, which until a few years ago was not really a field. We had mediation and we had international commercial arbitration, and literally never the twain shall meet. So I was asked to participate in a symposium at Washington University, just down the way from Mizzou. And it was on large-scale disputes, as I recall. And I started thinking about, well, I don't want to do what I've already done before. I want to do something new because I'm that way. And I thought, time out. Why is international mediation, or why is mediation not a big thing in the international commercial world, which I'd said to my colleagues at Mizzou for years. Thank you. I appreciate all you do, but it doesn't affect my world, which is international commercial dispute resolution. And I did a dispute system design analysis. And again, thanks to Mizzou for introducing me to that particular kind of methodology, that way of analyzing an issue. And I saw that there was basically a hole in the legal regime surrounding international commercial mediation, that there was no treaty that was in the equivalent of what's called the New York Convention, which assists with the enforcement of both arbitration agreements and arbitral awards. So I proposed in this article I did for the symposium, I did the analysis and then proposed a new treaty. And normally when people in international law propose a new treaty, it just kind of sits in the waste paper basket. Nothing happens with it. But I was very fortunate to be going to a public meeting of the Advisory Council on Private International Law that's held by the U.S. State Department. You may or may not know this, but the U.S. State Department is excellent at kind of bringing on stakeholder views in terms of how to develop the law. Not every government is as transparent and is as willing to take ideas from different kind of parts of their stakeholder realm. So I went to the meeting, which was looking for a new project for the UNCITRAL Working Group 2. UNCITRAL is the United Nations Commission on International Trade Law, and they are responsible for promulgating mediation rules, arbitration rules, and other sorts of dispute resolution mechanisms in the area of international commercial kind of law. And I said, well, hey, I have this article, and I really think we need a new convention. And I managed to catch the ear of a wonderful individual who was an attorney advisor there at the time, Tim Schnabel. And he and I started working in creating a stakeholder group. And so many of the people on this call were literally rung up by Tim, brought on board. We started convening meetings here in the United States. We then, just a matter of months later, went to the United Nations with a proposal for a new convention. Tim did not take all of my recommendations, but he took a number of them. And from then on, I assisted Tim, the U.S. delegation, and UNCITRAL as a whole, conducting some empirical research, acting as an NGO, as indeed, again, a number of the individuals who are probably listening to this as well. The convention, which is now known as the Singapore Convention on Mediation, went through in record time. Literally, I think we proposed it in June 2014. I think it was either 2014 or 2015. And I was telling Dwight, I had my notes a few days ago and I managed to lose them. So I don't have it in front of me. I just put my notes together very quickly. So it went through in like 4 years, and then was signed at this gala event in Singapore on September 9th, 2019, I believe, and went into effect a year later. On signing day, we had something like 40-something signatories, which is amazing. And we currently have 55 signatories and 8 states parties, and it is in effect. This is massive and huge in the international realm. But again, it was the combination of my international commercial arbitration expertise and this mediation, I don't even want to say expertise because I wasn't an expert, but this interest gleaned from my colleagues at Mizzou, putting them together and seeing what came out of it. So that's the explanation of what I've been doing and why I'm in front of you today and feeling so honored. But hopefully it's also an inspiration to you who are scholars or practitioners to do the same in your own work. I am sure that you have at least 2, possibly more, areas of interest and expertise, and that interest may be only an interest. You may not yet have an expertise, but trying to see how they go together to create something new. Again, scholarship is all about creation of something new and delving into areas that are of interest to our readers, who are judges and legislators and policymakers and practitioners. Putting those 2 things together and kind of seeing whether it makes sense is very, very important. So going forward, I'm going to encourage you all to think that kind of creative and innovative way about your own research, about your own work, both for your benefit as an academic in getting published, and for the benefit of the legal community. So again, thank you to Dwight for the very kind introduction. Thank you to the ABA and to the section, and thank you all, and have a lovely virtual meeting.